My name is Professor Darryl C. Wilson. I'm the Associate Dean for Faculty and Strategic Initiatives here at Stetson University College of Law, and also a Professor of Law here.
All right, so I wanted to ask you about this lawsuit, and it's part of a series of lawsuits, but the main reason I'm interested in this one is one of the defendants, Armadillo, is based in Tampa. And so they make Dean guitars there, which have a guitar shaped like the Flying V, and they make the Destroyer-shaped one. And also Luna guitar is part of Armadillo, which makes what's called the ES335, and Gibson ES335, it looks like that. So what can you say about how trademark law would apply to a case like this, and what maybe the judge would be looking for in this case?
Well, this is an interesting case from the standpoint of when you think of a trademark, most people think of a name and don't realize, unless they're in the legal field, that you can trademark a shape. And so trade dress or shapes can also be protected, and that's what's at the core here. So much like any dispute in trademark law, though, what the judge will be looking at is whether or not the protected subject matter is distinctive. You need something to be distinctive in order to be able to get a trademark registration for it in the first place. And then also on the other end, has it been adequately policed once the trademark was procured, or has it been allowed to be used by the general public in a manner that gives rise to a claim that it's generic. Generic in legal parlance for trademark attorneys means that it's common. It's gotten so common that that is the reference point for the average citizen. And so that's something that a trademark holder wants to protect against so that they don't lose their trademark.
Well, let's talk about whether they're distinct, and maybe if you could just talk about what the Gibson Flying V looks like to someone who can't see it, and then the Gibson ES335.
Right. The Gibson Flying V is, you have a long neck, and the base of the guitar is shaped like a V. There is, the cut in, so it looks just like a V with a long neck at the top of what would normally be, the bottom of the V. The ES335. 335, yeah, it's more of a standard guitar figure 8 shape with cutaways. What most people would think of when they say, I want a guitar. Somebody says, I want a guitar, and you go into Guitar Center, most of the guitars look the same. You see somebody who's a professional on stage with something out of the ordinary, then they've had a custom-made guitar. But the V, the Flying V, it was very different when it was introduced. The ES355, I'm not so sure if that was very different, but today it looks like what the average citizen would think of as a guitar.
So how much does that play into the law, where if an average person looks at a guitar and says that's pretty much what a guitar looks like, and then Gibson comes and claims that that's something that's trademarked, so if someone makes a guitar that looks like that, they should be stopped. How much would that play in?
Well, that's where the legal arguments come into play. Gibson would have to show that they had a registered trademark, which in these cases that they've been filing in the recent decade, maybe since the turn of the century, since the 2000s primarily, when they decided to be aggressive, they are pushing the fact that they do have a registered trademark, and so the presumption is in their favor, but that's a rebuttable presumption that the trademark was properly granted at the outset, and also that it's of continuing viability. So defendants in these cases would try to show that they didn't adequately police their mark, and therefore they allowed this to be commonplace. And if it's commonplace, then in legal parlance, that means it's generic and no longer protectable.
And that goes to the second point that you were talking about earlier, that there just seem to be a lot of guitars, even that something as distinctive as the Flying V. There are a lot of brands that make that.
Yes. That's the problem that's not foreseen. And then when it starts to rise, as a business person, you're thinking, well, this is a good problem. Everybody wants one of these. And when you're a pioneer, meaning in legal parlance and IP again, you're one of, if not the first in the field, then everybody who wants one is coming to you. Gets spread around so quickly, so fast, it outstrips your ability to police everyone, and you don't want to police everyone in one sense because you want the notoriety, the profitability, but you also risk the fact that it can become commonplace in the minds of the general public. And that happens all the time. It happens with, all sorts of subject matter. If I say I have a scratch on my hand, I need to cover it, you're going to say, do you need a Band-Aid? Is Band-Aid protectable now, or is that what everybody says anytime they need something? I need a copy of the complaint in this case. Will I tell you to give me a photocopy, or will I tell you to give me a Xerox? So Xerox spends lots of money, millions, trying to keep people knowledgeable about the fact that Xerox is a protectable trade name, so they don't go the way of many common things that we think of today that were once actually protectable trademarks, like trampoline, escalator, shredded wheat, go on and on. It happens all the time.
This case that involves a defendant that's in Tampa is just one of many cases around the world. In fact, I'm reading today, Gibson loses Firebird body-shaped trademark in the EU. So Gibson is losing some of these cases in the EU. Every case is going to be different, but what would make one case different from another, or what would, or maybe even a different question would be, how are the laws in the EU different from the laws in the U.S.?
Well, these are private business cases, so they are going to the private courts, and I haven't read that story. The EU is an interesting place to compare law because there's not a United States of Europe, and so in that regard, there's no federal law. The EU does have some directives, and they have set up some courts, but it's different there. If you get a trademark in the EU, it doesn't necessarily mean that it's enforceable in every nation state in the EU, because they're nations, they're not states. So if you get a trademark in the U.S., you get a federal trademark, then it's enforceable in every state, whether the individuals in that state are aware of it or not. You have national coverage, but there is, the EU is made up of nations as opposed to states. They call themselves states in international parlance, legal parlance, but they're nation states as opposed. So they all have their own independent law. The law that Gibson's trying to enforce here in the U.S. is, under federal trademark law. When they go overseas, federal trademark law in the U.S. is not important. So the question becomes what type of protection they got where in the EU. And they've had these cases ongoing, so it's not, again, it's good information. At the very foundation, trademarks are trademarks everywhere. Trademarks are made for identification. And that means that the consumer can look at the mark, be it a name, shape, color, size, etc., and that'll inform them something about the source of that good or service, as well as the quality of that good or service.
Well, we've covered a lot, and those are the questions that I was thinking of. Is there anything else that I haven't touched on that might be important in this story?
Well, I think, in terms of the actual case, if they do get to court, it will be interesting testimony. There'll be surveys of consumers. The defense would like to have a jury. I'm not so sure that Gibson would want to have a jury because, it would be a jury of average citizens, and the question would be, when you see this, what do you think? You hold up a ES 355, is it 35?
35.
35. You hold up an ES 335 to the average citizen. You ask them, so where did this come from? They're going to be like, I don't know, Sam Ash or the Guitar Center. What do you mean? You ask, who made it? They're probably not going to know. They're not going to say Gibson. Same with the Flying V now. You hold it up and say, who makes this guitar? The average citizen probably is not going to say Gibson. And interestingly enough, there's some headlines that have tracked Gibson as of late. I believe it was even earlier this year, Gibson said, we're going to move toward negotiation as opposed to litigation. We're going to change our stance because the public was up in arms. I think Gibson put out a video that they had to take back, telling people, you are warned. Don't use our guitar shapes. And, the general public doesn't take kindly to that. Everybody knows Gibson. They're the big boys, and they think they're coming out trying to bully people, the average citizen. So it would be interesting if it went to court. I think Gibson should, go back to that stance of being, wanting to negotiate as opposed to push these forced litigation or settlement.
Well, great. Thanks so much for your time. Thank you.
Sure thing, anytime.